Okay, good afternoon and welcome to this public meeting of the Standing Committee on Government Operations. My name is Julian Morse. I'm the MLA for Frame Lake, chair of this committee. This afternoon we're holding a public reviews of the Human Rights Commission annual report and the Information and Privacy Commissioner annual report. As Standing Committee on Government Operations, it's our responsibility to review the statutory officer annual reports every year. Please note that today's meeting is being live streamed on the Assembly's social media channels. I would like to remind all members and witnesses to please direct all comments and questions to myself as chair. This helps keep the meeting organized and running smoothly. I will now ask members to introduce themselves, starting with Ms. Reid.
Hi, good afternoon. I'm Kate Reid, member for Great Slave.
Good afternoon. Thank you very much. Robert Hawkins, MLA for Yellowknife Centre, and happy to be here.
Hey, my name is Richard Ajeric. I'm the MLA for Trinidad.
My name is Jane Wayellen Armstrong. I'm the MLA for Murphy, Cleacher Region. Thank you.
Thank you. So I will now invite the chair of the NWT Human Rights Commission, Mr. Charles Dent, to please introduce your colleague there and proceed with your presentation.
Good morning, Mr. Chair, or good afternoon, Mr. Chairman and committee. With me today is the Executive Director of the Human Rights Commission, Nicole McNeil. You've introduced me, so don't have to say me again.
With your presentation.
Mr. Chairman, the Commission was pleased to be able to get back out to our communities in 2022-23 after moving our community engagement online because of COVID-19. Throughout the year, Commission members and staff participated in many community events to deliver human rights-related training. Our outreach is varied and includes participation in events like the annual Anti-Poverty Roundtable, the local government administrators, and the NWT Teachers Conferences, and delivering presentations within our schools and community organizations like CDETNO, Commission member Gail Sear participated as a panel member in Restorative Justice and Reconciliation Learning event hosted by the Law Society of the NWT. All Commission members, the Executive Director, and 2 staff visited Fort Simpson, where we held our monthly meeting, met with local leaders and organizations, engaged with students of all ages, and hosted a very well-attended community meet and greet. Our second visit was to Norman Wells, where Commission members Dr. Yakub Adam and Norman Yakeula were accompanied by 2 staff members and engaged with community leaders and school students. On International Human Rights Day, the Commission hosted a panel discussion focused on sexual harassment and gender-based violence. During the same week, our Facebook Action campaign focused on learning how to recognize, support, and reduce sexual violence and discrimination. The Commission was pleased to award the Accessibility Award to the Jumpstart Inclusive Playground in Yellowknife. We recognized the Jumpstart program, local Canadian Tire owners Jason and Karen Budarak, and the City of Yellowknife in an important collaborative community-minded project that demonstrates how universal design can benefit everyone in a community. For the year ending March 31st, 2023, disability was once again the #1 ground included in complaints. 59% of all new complaints in 2022-23 included an allegation of discrimination on the basis of a disability. A continuing concern for the Commission is how builders and governments rely on the National Building Code to set building standards for accessibility. Last year, in response to the Commission's recommendations to the Legislative Assembly on accessibility, the GNWT's Department of Infrastructure stated they do not currently have a mandated role to play in the accessibility standards for private and municipal infrastructure. That, of course, could be rectified through legislative change. The Commission urges the GNWT to re-examine this mandate and to consider how accessibility is important to persons with disabilities and others, including seniors, parents with young children, and neurodivergent people. Shifting thinking toward person-centered services means that spaces and processes are prepared to meet everyone's needs. The Commission continues to encourage the GNWT to adopt an updated building code that better reflects CSA standard B651-23, as well as joining 7 other Canadian jurisdictions to develop its own legislation to guarantee accessibility for people across the territory. The Commission organized a system-wide training day on neurodiversity facilitated by the Institute for Research and Development on Inclusion and Society. 3 members of IRIS gave a brief introduction to their work and an overview of legal capacity and its effect on the rights of persons with neurological impairments to make their own decisions. The Commission invited participation from the NWT Disabilities Council and the members of the Native Women's Association. With IRIS help, the Commission explored the intersection of accommodation and legal capacity as it might apply in our education, compliance, and adjudication processes. The Commission has made a commitment to continue to explore the emerging area of neurological disabilities and improve our service provision to all clients. The Commission committed to review its reconciliation strategy to identify areas in which it can be improved. We want to continue working with Indigenous people and Indigenous governments to provide inclusive services that help reduce barriers for Indigenous residents. The Commission has commenced a research project into how we can better serve our communities with the assistance of a third-party research team. This project will focus on engaging with our Indigenous and new Canadian populations in Yellowknife, Dilo, and Deta with the goal of expanding into other NWT communities in the future to better inform our outreach and compliance work. The last of the changes to the NWT Human Rights Act came into effect on April 21st, 2021, which means the Commission has carriage of all complaints filed after this date that are referred to hearing. Carriage means that the Commission is responsible for putting the facts of a human rights issues before an adjudicator. It doesn't mean the Commission represents the complainant. The Commission's legal counsel will be responsible for representing the Commission at hearing and will advocate for and promote the public interest by encouraging a process that is efficient, effective, and as non-adversarial as possible. Some of the ways the Commission will do this include requesting active adjudication when one or more parties are unrepresented by legal counsel, identifying broad policy and systemic issues when appropriate, and advocating for a broad and generous interpretation of human rights legislation. We anticipate having carriage of the first complainant adjudication this fiscal year. Our restorative dispute resolution process allows complainants and respondents to resolve their own issues with a facilitator. This supported process is resulting in consistently high rates of settlement. Since the implementation of our restorative dispute resolution process in 2019, settlement rates have increased. Now, over half of all complaints are resolved by parties themselves before the need for an adjudication panel hearing. And you have in your copy of the remarks a chart that shows the change from 2017 to 2023. We are proud of the improvements the Commission has accomplished, and our team is dedicated to providing a flexible, user-friendly human rights system for residents of the Northwest Territories. Thank you, Mr. Chairman.
Thank you very much for the presentation, Mr. Dent. Does anyone on the committee have questions for the Human Rights Commission? Mr. Hawkins.
Thank you, Mr. Chairman, and thank you to our Commission representatives. I'm appreciative of both of you here. First, I'll say I appreciate the public engagement. I read through what's in your reports. If I would certainly say, hands down, my favorites, if anything, speaking as an advocate, I would say if you can lean farther into the schools and the networks of that, that is where I consider the real win. It's not to say the middle age or the older age or write-offs in the sense of education, but if we can inspire our youth to realize what's we've defined as normal and reasonable in this context of standard and expectations, it's if it's treated as normal and taught as normal, then when we get to the later phases of our whether it's the fall or the winter years of our life, like we won't be probably digging in. And I know that's a bit of a broad statement, but that said, we all know change is so deeply and with great quality with the young, and especially when they can identify the purpose and the appointments of why you folks are explaining these things. So hats off to certainly the student and school application of your public education stuff. Mr. Chairman, I just have a quick couple of questions. One's about the adjudication panel, and in the sense they're responsible to you folks, and one is sort of like the application of some of the recommendation. Now, the first question really is built around the adjudication panel comes up with a settlement, and whatever the issue is how do they frame that and come up with those dollar amounts? And I noticed there was a consistent dollar amount about disabilities, both the access and the, we'll call it harm done or whatnot. And by no means these are not questioning the merits of these applications of concern and the awarding of the finding in their area. The question more is built around how do they come up with a dollar amount? Say this is now worth $7,500. I don't necessarily, Mr. Chairman, have an understanding as how they come up with these dollar amounts and where do they root from and what they mean, because I mean it's obviously complicated, so I'm not looking for a high detailed answer, but just a general context to make it a little understandable, because it does seem like a lot of money. Thank you.
Thank you. Mr. Dent.
Thank you, Mr. Chair. Unfortunately, the chair of the adjudication panel couldn't be here today. Normally, when we have these presentations, he is part of the presenters, or one of the presenters at these. And it would be, given the independence between in the system, but and the way that we have to be seen as separate from the adjudication panel, what I would prefer to do is to take questions that you may have for the chair. And I did tell him that we would pass on questions that may arise, and we'll be happy to ask him to respond directly in writing to the committee. But I would guess that it's precedent that, you know, it's not just, they don't just look at what's happened before in the Northwest Territories, but likely across Canada. But maybe Ms. McNeil can, she's a lawyer, so maybe she can answer better than me.
Thank you, Mr. Chair. I don't know if we had to announce that I'm a lawyer. That's fine. Yeah, so Mr. Dent's on the right track with that. So generally speaking, at hearing, the parties, including counsel for the commission, if we're participating as a party, would be doing case law research, both earlier case law in the territory, but across the country, looking for cases that are similar in fact pattern to what we're dealing with at the particular hearing, right? A case that's kind of similar as a comparator. And so what they're looking at are where the dollar amounts for, and this one in particular, I think you're referring to, Mr. Hawkins, is for damage to dignity and hurt feelings. And so they're looking at where's the trend in the valuation of such damage caused to the complainant. So it's always based on precedent, based on submissions of the parties. And then when you read the full decision, the adjudicator will usually set out the rationale as to how they got to that number, in which cases did they consider, or which cases did they put aside, saying, not appropriate to guide me in this matter.
Thank you. Mr. Hawkins, you have a follow-up question?
Yeah, thank you. Maybe what I'll do is I'll ask one more question in this area, and then I'll defer the, you know, and I'll wait in the queue for the next question. The next area, of course, by way of heads up, is I did want to talk about the building standards, but maybe I'll follow up on the initial question first, which is, I'm curious, in reading a report, and maybe I didn't see it, but or maybe it isn't clear per se, and of course I could have just missed it, is how often is there repeated applications of concerns, in other words, repeated complaints by individuals? And one of the questions that really is being driven here is, and I should make sure I pause, first of all, your reporting in your report is fantastic. It's definitely of high quality. And we've seen less quality, but yours is certainly very, very good. It fits in the high. And I was just curious in the context of your analysis, because you have a lot of information here, how often does an individual keep making the same complaint? And now this is Again, not based on the merits of the actual complaint, in other words, saying that the door doesn't work. The mayor pretty much is clear on that. You know, and if there's a ruling based on the door doesn't work, as an example, then the merits stand for themselves. That's not the issue. But there is worry about individuals treating it as an economic development opportunity. In other words, without sounding cruel and crass, Mr. Chairman, in other words, it's come up a few times that, you know, are one or two people lodging a complaint, finding successful and merited. Again, I stress merited. I'm not suggesting that they're wrong. And then applying that application to business after business after business, knowing that they're seeing an opportunity. And so, in other words, I guess encapsulating is, do you track and announce in some form or fashion that maybe an individual had done either one initial complaint and that was it, or they have repeated complaints of the same nature and there's one individual who's launched 23 complaints, as an example. Thank you.
Thank you. Mr. Dent.
Thanks, Mr. Chairman. In being a small jurisdiction, we have to be careful with how we report on that sort of thing, because it might point fingers. But in general, most of the complaints that we get are, I guess you could say, one-offs. So the vast majority are one-offs. Yes, there have been occasions when an individual's filed more than one complaint, but the bottom line is that if it's found to be a valid complaint, that means that we have work to do at making our world a better place. So it comes back, I think, to my comments in my opening comments where I talked about accessibility legislation. What's happening is that a lot of people out there don't understand that building to the building code does not meet accessibility standards. You can open up a building today that you built to the building code and face a challenge for accessibility the next day. And that's why we think that the GNWT should develop accessibility legislation, as 7 other jurisdictions in Canada have, to make sure that everybody knows what their responsibilities are when they put a building up or when they rent a space that's open to the public. That's really what the problem is here, is that people may not, owners of businesses may not be aware of what the rules are around accessibility. It's the Legislative Assembly that said, these are the things that we want to see. We want to see equality. We want people to be equally able to access places. So, you know, if somebody's filing a complaint and it's found that the business is wanting for meeting the standard, that's a standard that you have set. And so, you know, we have to either, if there's a concern about that, then it's the legislation that needs to be changed.
Thank you, Mr. Dent. Does anyone else on the committee have questions for the Human Rights Commission? Mr. Jericon, I've got you.
Thank you, Mr. Chairman. And I was going to say thank you to Mr. Denton for coming in and your colleague coming in to do a quick presentation. I'm just thinking about, I was involved in the 19th Assembly and when we put forward the UNDRA bill, and it's now moving forward in this government in the 20th Assembly in regards to developing work plans and making laws and policies to accommodate the UNDRA bill that's been passed. Going forward, I just wanted to know, is that something that you guys are looking at, and what kind of impact is that going to have on your business going forward? I just wanted to put that out there. Thank you.
Thank you, Mr. Dent.
Thanks, Mr. Chairman. It's certainly something that we have been actively promoting. I know as long ago as 10 or 12 years when I was first appointed, the UN Declaration on the Rights of Indigenous People was a big topic among human rights commissions all across Canada. And we took the position then that governments across Canada should be enacting, as this Legislative Assembly has done, the same sort of thing to empower or to make sure that the rights are being respected. We're quite happy to act as a resource, but we also have to be cognizant of the rights of Indigenous governments to, you know, they are not, we can't step into places because we're under territorial legislation. So it's a situation where we're cognizant of it. We're trying to be helpful and supportive. We offer resources to Indigenous governments, even though they're not subject to coming before us. But we're quite happy to assist with, for instance, learning about restorative practice and the things that we're doing. We've actually worked with at least one Indigenous government, I think, to provide facilitators to help them resolve the situation. So we're quite happy to work together. We're well aware of the UN declaration and very supportive of it.
Thank you. Mr. Jerican, do you have a follow-up question?
In your deliberation, when you guys do meet, or in regards to your work plans and policies that you guys have in place, do you guys make available, say for example, if a complaint comes in Chippewa language, for example, by a member, I would assume that you guys probably just bring in a translator and that type of thing to help bridge the gap in the communication of the complainant in your department. Let's see.
Please.
Thank you, Mr. Chair. Yes, of course. We would usually work with ECE, who has a group of interpreters available to come in with us. We also are always open that if the individual complainant would like their own person to come in, that someone they're comfortable with, who acts as almost a support person and interpreter, as long as we're confident that the interpretation is happening and it's accurate, we're always open to that.
Okay, thank you. Another chance for first round comments before I go to second round. Ms. Whalen Armstrong.
Okay, thank you for the presentation. I just want to ask on this annual report, inquiries by region and new complaints by regions, and out of the whole, there's about 354 complaints or inquiries by region, and a big portion of it, 199, is from North Slave. I just want to know, can you tell me how many of those are from Klitschko region? Because Klitschko region consists of 4 communities.
Thank you. To Mr. Dent.
Thank you, Mr. Chair. We'll have to actually see if we can separate that out and maybe respond to your committee. So we need a few days to get the answer back to you.
Fair enough, thank you. So respond in writing. Ms. Whalen Armstrong, do you have a follow-up question?
Thank you. I think that's good, because I know that there's a lot of issues. There's a lot of things that are going on in North Slave regions as well. Just like recently with that Yellowknife Women's Society, they brought forward some complaints regarding other public service. That's why I just want to know, because if this is going to help us to make some changes, maybe we can, make some informed decisions and to move forward. Because right now it says North Slave, and what are we going to do? I would like to know, or I think my leaders, I think they would like to know how many of those were from Klitschko region, so we can do something. We can, work around it. Thank you.
Thank you. I'll take that as a comment, but Mr. Dent, if you want to respond, by all means.
Just to reiterate that we're happy to provide the information when we can put it together.
Okay, thank you. On to the second round of comments. I have Mr. Hawkins first in line.
Thank you very much. And I just want to go back, not to spend a lot of time, but I want to go back, and I don't disagree with the comments made by the chair, like as in responsibilities and whatnot. And I don't want to go through them all, but I want to say I somewhat agree with pretty much what he said earlier. So I just want to make sure that that's clear. That said, the other question I have, which is I do like your report, your sort of semi-plain language summary of stuff, and I think that's very helpful for folks, for the public that does choose to read the report or get a sense of what's actually happening. I think that's of great value to individuals. Now, that said, it's not a proactive tool. It's just in other words, the report's there. Typically, people trying to avoid human rights complaints probably don't go to the report and say, what type of things do, walk around their building saying, what category do I fall into? I'm curious from and this sort of leads into the next question area, which is sort of the building standards. One of the recommendations you make about is applying or suggesting or applying concerns, building standards to buildings that have challenges. And I'll frame the complaint about, I'll frame the observation around sort of how the complaint works, as you folks know. I mean, complaints made, found valid enough, as you guys know. This comment's mostly for the public. The next phase is it goes to adjudication and support, and then there's a direction and settlement. You know that the public needs that little bit of process or qualification. In a particular case, although I'm not here to ask you in any form to explain the adjudication's decision, but there lies the question or the challenges. The adjudication awards the settlements, which is again merited. Then they award a decision based on a recommendation that they have to respond to. And the affordability of businesses responding to some of these things are a difficult challenge. And so I'm familiar with a case where the occupant business had to respond to the financial burden that the landlord didn't. In other words, they were told, well, it's your problem. And so they were at risk of feeling the challenge of meeting the obligation set out in the direction of the adjudication. So again, I'm not challenging the adjudication decision. That's not the issue. It's the affordability of now carrying the costs on, because buildings are built to a standard, as the chair has mentioned, and there are standards of today that we recognize that don't necessarily fall into the ethical value or the community value we define it as holistically that may be or should be in there. My worry is the individual costs of buildings, and the fact is buildings and building operators. So therein lies the question. Has there been any investigation or consideration or awareness on your part that can help support building owners or business operators to help address some of these things in A, a reactive manner, but B, as a proactive manner? So, and I can say I have experience, personal experience on helping clients work with accessibility ramps, things of that nature. And I can tell you it's a bit of a challenge and undertaking. So if you're a business at risk, I mean, A, the last thing you need is a judgment against you. But the other thing is how do you fulfill the judgment when you're operating in a difficult time? So that's, again, not questioning the judgment or the value of the judgment, just how does it roll out is the worry I have thereafter. Thank you.
Thank you. Mr. Dent to respond.
Hi. Thanks, Mr. Chairman. The general rule in accessibility is that accommodation needs to be provided to the point of undue hardship. There's no definition of undue hardship. It's something that is unique to every situation. So when the Legislative Assembly is found to have done something that isn't accessible, the level of what is required to fix it is much higher than it might be for a small business. But that's the sort of thing that when a decision about what constitutes undue hardship, the parties have to make submissions, and it's the adjudicator who weighs those submissions and then says, in my opinion, like you can afford this. An adjudicator is like a judge. We didn't, there's no difference in the way they make their decisions. It's pretty much like a judge. Their process has become a lot more accessible since the Legislative Assembly said that everything that we do has to be restorative. And I can tell you that that folks who interact now are finding it a much better. The interactions are much better, much more, or much less adversarial. And in fact, if you take a look at the chart, which shows you that, for instance, in our office, that settlements have gone from 43 to 45% before we went restorative to a high of 68% in the year covered by this report. That just indicates what's happening with our approach now. It used to be a system where everything was headbutting. You got into a he said, she said, or we did, we didn't, or they didn't situation, and everybody fought. And what we now do is bring people together, and there's a chance then for people to discuss what is possible, what could happen to resolve the situation. And it's working, we're finding it's working way better. We're finding that, you know, it's not always a money settlement, in fact, that sometimes it's just an apology, and yeah, I'll train my staff so they don't do this sort of thing again. So we're trying to get away from as much as possible, away from having the court-like atmosphere and having the court-like decisions and having parties resolve among themselves. And we're finding that it works quite well. So I think you'll find, you know, members around this table will find that over the next few years, having adopted this, that you'll actually hear fewer and fewer complaints from your constituents because of the way in which this process now works. And it was totally broken, you know, 12 years ago. It wasn't working at all. Nobody was happy. Could I ask Ms. McNeil to have an opportunity to add, please?
Mr. Chair, I just want to add to Mr. Dent's comments from the perspective of the proactive type of approach. It's certainly our experience that usually when a property owner, when we're having to call that property owner to say there's been a complaint filed, it's not because they don't want their business to be accessible or their building, their apartment building to be accessible. It's more of a lack of awareness of what are the standards. Which is why when we saw the trend of numerous complaints coming in about accessibility, physical barrier accessibility, the Commission identified that as a systemic issue across the territory, which is why so much effort and resources has gone into our own proactive public-facing education on accessibility. It's also why we come and talk about wanting to encourage government to adopt an accessibility legislation so that all property owners and builders understand what needs to be done to make buildings truly accessible. In terms of the consideration of the fiscal impact on builders and operators, that's why we would like more people to be aware of what's required on the front end so they're not caught with not understanding and then receiving a complaint. Certainly at adjudication, if it's gone that far, parties are free to make sort of the undue hardship argument about once there's been a finding that it's not accessible. Certainly fiscal ability to carry out the repairs is considered. Usually that's not going to result in you don't have to make your building accessible. What it might result in is a longer period of time that the adjudicator would put in place to comply. Right, so to be able to budgetarily plan for being able to make the renovations. So usually the fiscal ability won't get you off the hook completely because it does have to be accessible to be in line with human rights legislation, but they try to acknowledge, as Mr. Dent was saying, the difference between a large employer or government entity versus your mom and pop corner store and their ability to carry out the renovations.
Go ahead, Mr. Dent.
And just, we have been really trying to be proactive. We've developed a toolkit for folks to help them understand what it takes to make an accessible place. We've developed a toolkit to help people understand how to make an event accessible. So it's not just the physical location, but making your event accessible. We are developing these tools, and we're reaching out to construction associations. I've made presentations to the Construction Association, just to try and make sure that people are aware that they need to look beyond the building code. That the building code doesn't protect them, and to understand how to make it a space truly accessible, you need to look at other standards like the CSA standard that I mentioned.
Okay, thank you for that comprehensive answer to an equally comprehensive question. Second one to Mr. Hawkins.
Thank you, Mr. Chairman. Just by brief follow-up on that particular one. I would encourage the commission to write all municipalities, their planning departments, and send them a submission, a general submission of sense based on, say, here are some principles we're seeing from the design point of view, under our envelope of human rights, things you may want to consider in your packages of those who apply for building permits as they apply. I don't know if that's the case now you do this. I would also encourage you to consider reaching out to NAPEG and trying to get them to consider that as part of the process of what they do. And the problem with voluntary stuff is, the issue with voluntary stuff is it's treated just as that. And it's when it's no longer voluntary through a decision, then it becomes something else. So it's a suggestion of those two organizations. I mean, obviously there will always be more, but I mean, it's a suggestion, at least, by way of example, if you go to the city of Yellowknife and it's part of the planning on lands application process, that up front it's given to you as things you may want to be aware of. And hence that's, and in there is a folder of some of the things, like a little folding thing of some circumstances and some observations made that can happen. I mean, no one's saying they ever will. That's the tricky thing. So that's just an observation on the last one. And the only other question I have, Mr. Chairman, at this time, and I'm known to come up with a few more, sorry, but the only other question maybe to just flesh out a little bit is the Human Rights Commission has the ability to carry money over. And I can stress that's a very unique circumstances, and even Chairman Dent would know, being a former member of this assembly and even finance minister at one time, it's a very unique experience to hear any agency or have that ability. So not testing the merits or the arguments of how you got there, because I mean, obviously a decision's been made and I respect that. What I am going to ask is, my understanding is it's something to do with training or the ability to do that. Can you explain how the intent of that carryover is targeted at, and do you have a plan that's using it? Do you have a focus or a narrative that you can help explain? Not so much why you have it, but why you have it and what it's used for. Thank you.
Thank you, Mr. Dent.
Thank you, Mr. Chairman. To Mr. Hawkins' first comments there, we've attended for several years now the LGANT conference. So we've talked to administrators and made that very presentation that Mr. Hawkins was asking about to them. We've worked with chambers of commerce to try and get the word out to businesses about it, and we've worked with construction associations. So we're trying to be as proactive as possible to get the word out about the building code not being adequate guidance for somebody who's putting up a building. In terms of the surplus, obviously, if you're beholden to anybody for your funding, then there's always the public going to say that you are subject to their whims. And so I think the initial reasoning for the independent, or for the carryover funds, was for independence. What we're planning to use it for, and we've started this process last year, and we will finish it this fiscal year. We issued a contract for some research, and the Act directs us to conduct research. This is the first time since the Commission was established in 2012 that we've been able to put enough funds together that we could start the research. So we've been diligently squirreling away money until now, and we're starting to spend it to get some of that research. The initial research project is focused just on Yellowknife, Dilo, and Deta, but we're hoping to use this as a proof of concept. And if the information that we get looks good, if the process looks good, then we're hoping to expand it across the territories to get better information about how we can do our work and have more impact on the people of the Northwest Territories. And if I can go back to Mr. Hawkins' very first comment, I'd like to thank him for talking about education. We certainly agree that is and should be our focus. When we go to a community, the first people we contact are the principals of the schools. And we try and we typically won't go into a community unless we've already set up with the schools to go there. And then the local governments actually are second in line, because for us too, the focus around young people is something that that we see as being extremely important. And I have to give credit to Ms. McNeil and her staff. They've set up a tremendous, almost curriculum that we use in the schools, and it's and particularly with the younger grades, K to 8, we are having a real interest and really good attention to what we bring to the schools. And it's more of a challenge, of course, when you get above grade 8, but even there we're getting some good conversations. And I think that we do, when we make our community visits, we focus on the schools. So thank you for that guidance, because we agree that it's the right way to go.
Thank you very much. Giving an opportunity for second round questions to members. Do any members have further questions which have come up? Ms. Whalen Armstrong?
In your report, okay, so can you tell me what are the main reasons for so many complaints alleging discriminations against disability?
Oh, Mr. Dent.
I think I'm going to ask Ms. McNeil to add into this, but I think disability includes neurodivergence. It's not just physical disabilities, it's all disabilities. There are a lot of complaints about disabilities not being accommodated at work, for instance. So it tends to be, and this is common all across Canada, all of the jurisdictions across Canada, disability tends to be the first. But Ms. McNeil deals more directly with them. I'd like her to answer.
By all means, please.
Thank you, Mr. Chair. Yes, to add to Mr. Dent's comments, in the areas that we engage with, so employment, tenancy, and public services, all three are areas where we see disability complaints arise out of, right? So your apartment is not properly set up for accessibility purposes, the business is not accessible, or in the employment sphere, it's more about the accommodation requests that an employee is making to be properly accommodated in the workplace. Out of those three areas, employment is certainly the biggest area of employees seeking accommodation at work. The reality of the nature of the disability can be complex. And so we don't see very often an employer simply saying, there's no reason I need to accommodate you. The answer is no, right? So it's not that sort of stark, I refuse to acknowledge your human rights and I'm not going to accommodate. It's usually the process process of trying to figure out the appropriate accommodations, and that's where the challenge arises most often. You may have an employee who believes they know exactly what they need, and that's what it's going to be, and it's not as black and white as that, because then you're getting physicians involved, and you're having medical prognosis, and trying to figure out what works for the workplace as well as the employee, and the balance to be struck. But yeah, it's definitely a complex area. We have some complaints where the nature of the complaint is not a one-off incident, but a storyline that covers 2 years of working with their employer to try to figure out appropriate accommodations. So yes, as Mr. Dent mentioned, disability being the highest ground that we see filed is the trend across the country. And it's in part why we do so much advocacy about accessibility as well, because the inclusion of folks with disabilities at the workplace, in our businesses, in our apartment buildings, is something that we've been pushing for.
Thank you. And certainly we have a lot of work to do in Canada in terms of accessibility. That's been highlighted to me as a councillor. Ms. Whalen Armstrong for a second question.
So, thank you for the information. The reason why I asked that is because with a disability, this has to do with the vision, okay? And I know that the minister has said, or previous government, 19th Assembly Minister, ECE, said before that they're trying to streamline. This has to do with income support or disability allowance. Okay, so I'm just wondering if you guys are working with the government of the Northwest Territories regarding some of these programs that people with disability, especially with the visions, are eligible, you know, for some of these programs, because some of these, some of the people that we represent, they're not eligible for federal and territorial disability allowance because of the employment history, especially with the federal. They don't qualify for that. The one that I'm focusing on, or like I hope that we get it. You know, I want to see some changes for some of these people, because you know, living in the north with a high cost of living, especially in the small communities, sometimes you need 2 jobs. Okay, even though you know you need 2 jobs to survive, to pay for all the bills, and the one person, you know, it's not their fault, you know, because sometimes it's like you said, genetics, and it's the way that I see it, and then the way that because we've been talking about it, that they fall through the cracks, that they're forgotten. Nobody even nobody even contacted some of these people. How can we help them? You know, and especially if they have a spouse. So I think that's for me, I see that as a discrimination, because they have a spouse that's working, that they're nobody's responsibility. And I think we need to, you know, look into that matter and try to fix it. Because in the small communities, well, I don't know if you guys lived in the small communities, but in the small flying communities, especially flying communities, it's hard. It's difficult to make ends meet. And even in our community too, it's the same thing. You know, like I know we do have a lot of people with some challenges. And so I was quite pleased when the minister said that they were going to streamline, but we're still, you know, having issues. We're getting phone calls at the end of the month, you know, from many of our clients, and it doesn't seem like anything got resolved. So I just wanted to know if you're working with, but I can talk to you after, you know, like about it, and if you're working with the NWT to resolve some of these issues. Thank you.
Thank you, Mr. Den, for a response.
The Commission is always willing to act as a resource, so to help people understand what best practices are and so on. We don't, you know, unless there's a complaint, we don't really have an authority role, but we certainly, we would have to find, we're not sure that, I mean, without knowing the details, it would be hard to say whether or not a complaint would be appropriate, but we'd certainly be happy to work as a resource to help make sure that best practices are what are being followed. So,
Ms. McNeil.
The one thing that I'd like to reiterate to Mr. Dent's comments is when a constituent is approaching any member, if there's any concern that there could be discrimination, please encourage them to call our office, because it is a confidential process. In terms of working, in terms of like project meetings or consultation meetings with the GNWT departments, we always say yes when approached, but we can also do a lot on the individual files. So just because someone calls our office, the only way they're going to get resolution is not by the whole file going the distance and all the way to an adjudication panel, but the actual dispute resolution process that Mr. Dent was speaking about, where that's sometimes our most effective ability to talk to a respondent, to a government agency, about where we're seeing the potential pitfalls of the manner in which they're applying policy, or the rules that they're applying to individuals, where that can sometimes result in change by those confidential dispute resolution restorative discussions with representatives of the department. So always encourage anyone approaching with discrimination concerns to give us a call. Whether or not there's a valid complaint there, we don't know, but we certainly would like to discuss.
Okay, thank you. Just noting we are running out of time, but Mr. Hawkins, I got one last question for you.
Thank you. I'll wrap it up very easily. Well, I hope it's easy. I noticed on your page 13 of your report, and again, I really like the way you lay out your report. I think it's very helpful. Just an observation, and some of this may be laid out in legislation and regulation, and my first, I'm going to qualify them all, but I've got a couple observations. My first observation is the executive director or the commission is unable to dismiss a complaint. That may be technically correct from a legal point of view, but from a layperson point of view, that may sound terrible. So just as an observation, and again, it may just be a legal process that explains it, but anyway, it comes across as, from a citizen point of view, maybe a little abrupt. The other observation is this, if a complaint is dismissed by the Human Rights Commission for various reasons, I'm just curious as to what the appeal mechanism is, as in to who they go to ask, like I'm not convinced they got it right, they need to look at this. So where do they go? And the next aspect is, and again, keeping it in the nature of one, you have decisions. Is there rules around why the decisions in summary are printed in here? In plain language, or is that a choice by the commission? I mean, I think it's a good choice if it's a choice, I'm just saying, but is there rules around, because you have your summaries on the next page. And the last area, Mr. Chairman, just squeezing it all in together, is that if it goes to adjudication panel, who supports the individual? Is there a process that supports the complainant? And I don't mean, does the commission hire them a lawyer, but some people, it takes a lot of energy to bring forward a complaint and feel strong and steadfast to follow it through, and it's a daunting task regardless. And even as MLAs and the chair of the commission would understand that, sometimes it takes a lot of energy for individuals to come forward to bring forward an issue and feel confident, are they on the right page, are they going in the right direction, and they really need that extra support. And it doesn't mean that someone has to advocate for them, but it gives them that support mechanism. And that's a worry I have, that individuals bringing a legitimate concern forward aren't given the support they need. So that's why the question is. Thank you.
Thank you. Mr. Dent.
Thank you, Mr. Chairman. With regards to the language there, I'm not sure how much we can do. The way this system is set, in terms of the language, the way the system is set up with the latest revisions to the Act, the executive director can now decide to accept or not accept a complaint. So no dismissal there. So if the executive director chooses to not accept a complaint, the person has the appeal mechanism is to appeal to the commission. And if the commission then does not refer, if it chooses to dismiss instead of referring, the appeal mechanism is directly to the adjudication panel. So, and that's similar to the process, that appeal to the adjudication panel is similar to the process that was in place before the changes to the Act. And it's been used on occasion, sometimes successfully, sometimes not.
Go ahead, Ms. McNeil.
Thank you, Mr. Chair. And just to take it the one step further, if the complainant or respondent didn't agree with the decision made by the adjudication panel, so the summaries that you see, they of course have the ability to appeal that decision, but that decision is an appeal to the court, to the Supreme Court of the territory.
Okay, thank you. Oh, Mr. Dent, it looks like you have one last point to make.
I wanted to carry on, like Mr. Hawkins asked about support for unrepresented folks in this process. That's the biggest change probably that the Act brought in, is that now, going forward, complaints, the Commission's legal counsel will appear in front of an adjudicator and present the facts of the case. So they don't represent either side, but their job is to make sure that everything is presented. In the past, a complainant when unrepresented or an unrepresented respondent, they had to come up with their own precedent. They had to be able to present precedent, they had to present the legal arguments. It really was like appearing in a courtroom, and nobody had the training for it. So the whole system was bogged down and taking longer than it should. We're hoping to see that since right, going forward. It hasn't happened. That's why I said in my comments that we're hoping that this fiscal year we will finally get to implement the final part of the changes and see the carrying forward of complaints by our legal counsel. That should remove a lot of the issues about that people had when they were unrepresented. And one final comment is we've brought some materials, but I think MLAs should make sure they have copies of this in their office. It's in all official languages. It's an easy way for people to understand what we do and how it's going to happen. So thank you, Mr. Chairman.
Okay, thank you very much, Mr. Dent and Ms. McNeil, for that presentation. I really appreciate all the great questions from committee and your willingness to answer them in a comprehensive way. So this is going to have to conclude the portion of our meeting, as we've got another commissioner waiting, I'm sure, with bated breath to come and speak to committee. So we'll take a extremely quick break and hear from the Information and Privacy Commissioner when we return at 2:00 p.m. Thank you. Okay, I would like to call the meeting back to order. Before we begin, I would just again like to remind all members and witnesses to please direct all comments and questions to myself as chair. This helps keep the meeting organized and running smoothly. And we'll do member introductions for the benefit of Mr. Fox, starting with Ms. Reid again.
Hi, good afternoon. I am MLA Kate Reid for Great Slave.
Good afternoon. I'm Robert Hawkins, MLA for Yellowknife Center, and very happy to be here. Thank you.
Hello, my name is Richard Ajeric, and I'm the MLA for Trinity.
My name is Jane Way Allen Armstrong, MLA for Montpellier, Clinton Region.
Okay, and of course, I'm Julian Morse, Chair of the Committee and MLA for Frame Lake. So I'll now invite Mr. Andrew Fox, the Information and Privacy Commissioner, to proceed with your presentation. The floor is yours, Mr. Fox.
Well, thank you, Mr. Chair, and good afternoon to all the MLAs. All new faces around this table from last year. I will not try and get through my entire report. That would be impossible in 10 minutes. But I've got a short presentation I'd like to make, and then hopefully there may be some questions we can get into. So the report, which you may or may not have read, has some basic structure to it. There is, I wonder if we could change the slide. There we go. No, I've got mine. I'll be making passing reference to it, but everything you'll need to see will be up on the screens. The purpose of the report, obviously, it's a dual report, one under the Access to Information Protection Privacy Act, the other under the Health Information Act, and sort of general reporting requirements about the effectiveness of those acts and reporting on the activities that my office has had under those acts, and to make any recommendations that we might feel appropriate for the government or the Legislative Assembly to consider. So in terms of sort of general reporting, there's a financial reporting section at page 3 and 4. There's nothing particularly noteworthy there. We were on budget. We actually returned, I think, about 10% last year because of some sort of economies in spending. One of which was that we didn't spend as much on consultants as we might have. And we had our assistant commissioner retire during the year, and so there was a savings on salaries there. So those were the two sort of main points. There's some basic statistics about file loads in there. Notably, we had last year 177 new files. That's a significant drop from the year before when we had 329. And that's, I think, in large measure from the effect that COVID had on both access to information, but particularly on Health Information Act, particularly in that privacy breaches. We're still processing some of those matters, the privacy breaches under the Health Information Act, but the numbers I think are going to be going down a little bit more even this year. So there's, I think it's fair to say that there was quite a blip between 2020 and 2021, 2022, which were sort of roughly under that bubble caused by COVID. So it's maybe last year was the high water mark, but we're certainly not in a position to say that we're overstaffed and able to hit all the timelines in the acts yet. The experience that I've had as the commissioner has been one of fighting to tread water. So I think we're hopefully facing a bit of a subsidence in the numbers of files, but we have plenty to do. I'd like to talk about a couple of the recommendations specifically. There are 10 of them. If we could just change the slide to the one after this. There we go. Just check that. Actually, if we can skip to the next slide, please, to the recommendations. Get next one again. There we go. So I'm going to talk about these a bit and out of order. Actually, we'll go to the last slide, please, and look at recommendation number 5. And, just in general, throughout the year, we've sort of noted various things going on, and some of the things are important enough to bring to your attention. Number 5 is one that relates to the impact that COVID had on some of our operations. And the recommendation number 5, I'll read it out because people are looking at this at home, I believe. The GNWT should review the need for privacy protective policies and procedures to support a specialized emergency response such as the COVID-19 Coordinating Secretariat and ensure it is equipped to operate within the bounds of the Health Information Act. So even last year we had 55 privacy breach notifications that our office received from the Department of Health and Social Services. The department was where the Secretariat was situated, and although the Secretariat ceased operation in April 2022, the department continued to sort of discharge the obligations under the HIA in regard to that unit's actions. In addressing some of those privacy breaches, we noted a number of problems that would emerge frequently. First, there was some apparent confusion about the sort of status or relationship of the Secretariat with the department. The Secretariat was situated within the department, which in my view was entirely appropriate because the department is a health information custodian under the Health Information Act, and the Secretariat was not. But the Secretariat was intended to and did deal on an ongoing basis with personal health information. So it was appropriate to have that situated inside an organization that's regulated by that act. But there was a persistent apprehension, belief that somehow the Secretariat was separate from the department. That may have had something to do with the management structure and management resting with the Premier's office, which is outside the department. But one of the things that came up was that there was a response that we got a number of times when we would ask for what are the policies governing this or that aspect of your operation in the context of a privacy breach. Now, under the ministerial directive from 2017, all health information custodians are supposed to have a privacy breach policy, and indeed the department had one. And it was not just a policy, or is not just a policy, it was also a set of procedures on how to deal with privacy breaches. Identifies things like an authorized employee who is the sort of first contact when their privacy breach is discovered. And unfortunately, the Secretariat responded a number of times saying, we don't have such a policy and we don't have an authorized employee. which is strange because they were situated in a department that had one. And that, that's a problem that was problematic when we were trying to deal with these instances of privacy breaches and figure out why they happened and what strategies might there be to avoid them happening again. Now, since 2022, or since April 2022, that's been largely a historical review. It's not an operating unit, but it does, in my view, demand some further future-looking attention because we need to have responses. The government needs to have a response when the next, be it medical, be it some other kind of emergency happens, and some sort of administrative structure needs to be created to deal with that response. And those responses need to comply with the legislation and not in sort of a ad hoc, we'll try and get it working as best we can when you're in the middle of it kind of way, but from a planning perspective. And when I reviewed the government's learning from the response to COVID-19 document, I noted that it didn't discuss the incidence of privacy breaches, and it didn't discuss the question of how to set up an independent unit in a manner that would be consistent with and complying with the Health Information Act. So the people participating in the Secretariat definitely to be commended for their efforts in helping deal with the public response, or the public health response by the government. But at the same time, my recommendation would be that the government needs to plan for the next response so the bureaucracy is ready to respond within the appropriate, applicable legal and policy framework. In my view, that these emergency events are things that will understandably cause more people to be more concerned with the actions of their government, not less. And in my view, that's not a situation that would justify relieving the government of its obligations, either under the Health Information Act or the Access to Information Protection and Privacy Act. Indeed, quite the opposite. So, I mean, it's tried to say that planning is an appropriate method for preparing for things, for events like emergencies, but it was somewhat disappointing to see no discussion about planning around this issue of privacy protection. And so that recommendation is sort of a generalized one, but it should, I think, fit in the government's consideration of emergency responses, and not necessarily just for health information. And obviously, the last year's fire experience created its own set of sort of emergency considerations. So I'll leave that. I'd like to discuss a little bit recommendation number 2. Maybe just flip back to the previous slide. And this recommendation is that public bodies should review their legal obligations to respond to access to information requests and evaluate their capacity to provide responses within the legislated time periods. They should also ensure, either collectively or individually, that the Access Privacy Office is appropriately resourced so that it can reliably assist public bodies to respond to access to information requests within the legal time periods and to comply with the relevant procedural requirements. So essentially this one is about resourcing for access to information functions, and in particular the Access Privacy Office. Last year my office saw a strange coincidence of a decrease in the number of applications for time extensions by the public bodies to respond to access requests, and at the same time we saw an increase in the number of complaints by people who didn't receive their responses in time. So the way the system works is if a public body needs more time to respond to an access request, then the Act says they can take one extension of up to 20 business days themselves. After that, they have to come to my office for permission. And notably, they have to do that before the time expires. Because if the time expires, then there's no more provision to ask for more time from my office, and it becomes, by operation of law, a deemed refusal or deemed decision to refuse. And then that decision to refuse can be appealed to my office. And that process was created in the amendments came into force in 2021. So it's new comparatively, and it was designed, from what I can tell, as a response to a perception that responding to access to information requests was taking too long by at least some public bodies. So the idea was put more scrutiny, more tighter control on the response times, and more scrutiny on it from my office, sort of having an independent arbiter of whether or not an extension is appropriate. But that whole thing only works if the public body comes to us in time. And I understand, talking to people at the Access Privacy Office, that certainly last year that was a problem, that they didn't have literally didn't have the practical time to apply for extensions, thinking that, well, if we don't do the extension or just spend the time applying for it, then that time could be more usefully applied to getting the actual response out the door. And, you know, there's a certain practical attraction to that, but it's not the way the Act's sort of laid out. And the concern, of course, is that sometimes then more intervening events happen, and the time for providing the response gets pushed further and further out. And when assurances are made by the Access Privacy Office to the applicant saying, well, I know we're out of time, but we're going to get it to you soon. Well, strictly speaking, the Act only provides an appeal period for that applicant of 20 business days, after which their right to seek a review ends. Now, I have taken the position that where the applicant says, you know, I've been told it's going to be coming and coming, and then several months later it still hasn't come, so now I'm coming to you. I've decided it's appropriate to exercise my discretion and do a review anyway. And this sort of material comes forward. It's a resourcing problem. The resourcing bottleneck seems to be certainly in large part at the Access Privacy Office, because they haven't had enough staff. They haven't had enough trained staff, and that's been a chronic problem. I understand that very recently they were able to hire one more person, and they're hoping to hire another. Whether that will be sufficient, I guess we'll wait and see. But the problem seems to have been that there wasn't a great deal of time spent evaluating what it would actually cost to run the system using a centralized office. And they wound up bringing it on stream halfway during COVID, and they didn't have the resources. Whether they'll be able to catch up, I'm not sure, because according to last year's administrative report to this committee, they're still late some 30% of the time, and that's probably not a sufficiently adequate service record. And I don't mean to be pointing a finger at the staff there, because I know that they work very hard, but there are only so many hours in a day. And when I see emails coming from people at an office on the weekend, I kind of shake my head and say that should not be necessary. So the recommendation is fairly straightforward, and it seems to me that ultimately the public bodies, and that's all the departments plus, you know, a host of several other public bodies that are independent of government departments, they are the ones with the obligation to provide the responses within the time frames. but with the creation of the Access Privacy Office and the devolving of a number of the really important duties, the real time-sucking kind of tasks in that process have been given to the APO, which is good because they have expertise, they can bring efficiencies to it, etc. But it's still the public body's obligation, and if they are not asking themselves, have we given enough resources to the Access Privacy Office, then ultimately it's the public bodies who are failing. And essentially it seems to me that government really does need to take another look, if it has not, at the resourcing levels in that office and determine what, if any, increases should be appropriate. And I know that this is a difficult sort of economic time for the government, but nevertheless, these are legal obligations. They're not policy choices. Okay, well, I've gone already past the 10 minutes I was going to leave myself, but let me just mention a couple of other recommendations, numbers 4 and 10. Now, recommendation number 4 is a recommendation that the Department of Health and Social Services should consider implementing a policy, or the Legislative Assembly should consider amending the Health Information Act to require health information custodians to report to the Commissioner, that's the Information Privacy Commissioner, regarding the implementation of accepted recommendations. So right now, under the Health Information Act, if my office makes a recommendation in a review report, then the health information custodian has 30 days in which to decide which, if any, recommendations it will accept, and or if it's going to do something else, and then it has a further 45 days in which to implement those. But there's no reporting structure to say, okay, we accepted the recommendation and this is what we did. Now, informally, we often, not always, but we often get some kind of reporting, specifically when I ask for it. Under the new regime in the Access to Information Act, there are a number of additional provisions in there requiring reports to the Commissioner following a decision to accept a recommendation. Again, those are new provisions. They came with the 2021 amendments, but they're useful because it really does sort of close the loop and make it clear that everybody needs to sort of circle back and say, okay, that's done or not done. But there should be some closure on what the final fate of the recommendation was. And lastly, I'll just mention recommendation 10, which basically echoes recommendation 8 from last year's report, and it deals with a requirement or a recommendation that the Legislative Assembly consider amending Section 89 of the Health Information Act to include similar provisions from the Access to Information Act regarding privacy impact assessments. That recommendation was made last year. The response to it made me a little concerned that maybe my recommendation hadn't been clear. And the Health Information Act, Section 89, does require privacy impact assessments. But the new provisions, excuse me, the new provisions in the Access to Information Act have quite a bit more detail in them about how they're to be prepared, when they're to be prepared, when they're to be submitted to my office, etc. And we have had historically some difficulties in getting the health information custodians to give us these things in a timely way so that we can read them and respond to them effectively. And just to give you an idea, these things can be quite complex, 20, 30 pages. It can take months. Sometimes it takes months just to get them signed off, but it can take months, if not years, to develop them. So if we got it on a Monday and say, well, we want to go live with this next Monday, it's a bit of a tall order for our office to turn stuff around that quickly. Basically, we can't. And privacy impact assessment is a very valuable planning tool. It's not an assessment tool. It's not a way to see how you did after you've already done it. It's putting on that privacy lens and thinking, in this new project, say it's an information system or a communication system, how will privacy be designed into it? And it can be a very productive way to spend the time. Of course, the legislature has already recognized that by placing it into the ATIP Act, because that was new in 2021 as well. So my recommendation is basically to look at changes to the Health Information Act in that regard. The Health Information Act is coming up for review. As you may know, it has to be reviewed every 10 years, and it came into force October of 2015. So next year, presumably the minister will be getting going on that. That's all I have to say at this point. I'd be very happy to take any questions you might have.
Okay, thank you very much for the presentation, Mr. Fox. And yeah, we'll go to committee questions. I have Ms. Reid first.
Thank you, Mr. Chair, and thank you, Mr. Fox, for your presentation. I have a great deal of questions, and if we don't have time for them, I might forward you further questions if that's all right by you. But I've tried to break them down and listen to what you just told us right now so that I don't perhaps repeat some of the information that you've added beyond the recommendations. So in my first group of questions, it's more around the machinations of requests. So you've asked that the Assembly to consider allowing that the IPC have discretion for extensions to the time required for a review. I'm inclined to agree with that recommendation, but I was wondering if you could speak a little bit more to that.
Yeah, thank you, Mr. Fox. Sorry, we just, in order for the cameras and microphones and everything, have to go through the chair. Apologies, by all means.
Thank you for that question. Recommendation 1 is all about building some flexibility into the system. Actually, was that recommendation 1 that you were focused on? I'm trying to remember what that was about. No, that's fine. That was discretion to extend the time required to complete a review. Yes, thank you. Under the Act as it stands now, the Act says that the Privacy Commissioner shall complete a review within 90 business days of receipt of the application. That never happens. I've certainly looked at that from a legal point of view with the question, do I lose jurisdiction at the end of 90 days? It is a mandatory section, and that certainly gave me pause initially, but there's, I think, a good legal authority to indicate, no, I don't lose jurisdiction. It would be quite a bit of mischief if applicants for review were denied relief simply because the time went beyond. And I've discussed that with the Department of Justice here, and they concur. So there's no dispute that I have jurisdiction. However, the section would lead your normal layperson to conclude, I think, that they could reasonably expect to have a decision on their review within 90 business days. And our office right now is nowhere near able to deliver that. So other jurisdictions have a similar provision, and some of them, I believe notably Alberta, has an express provision saying that 90 days, unless the commissioner extends it. And, you know, that wouldn't necessarily make a difference to the service standard that we're able to deliver, but it would certainly allow individuals to know, you know, more clearly where they stand and when they can reasonably expect to get a decision. So that's what that one's about.
Thank you. Ms. Reid for follow-up.
Thank you, Mr. Chair, and thank you for that answer, Mr. Fox. And yes, I'm sorry to confuse and conflate the two. I think I might have done that myself just now. But could you also speak a little bit to recommendation 1, just for clarity as well, please? Thank you.
Thank you. Mr. Fox.
Sure. Thank you, Mr. Chair. So recommendation 1 is that the Legislative Assembly should consider amending the ATEP Act to allow a public body to extend the time once for the period required to complete third-party consultation without authorization by the IPC. For subsequent extensions, public bodies should continue to seek authorization from my office. So right now, public body has nominally 20 business days to respond to an application for access to a record. Under Section 11, the public bodies can, on their own initiative, give themselves one extension of further 20 business days if they feel that under Section 11 they've got one of those conditions satisfied. And after that, they have to come to my office for any further extension. So the problem with third-party consultation is whenever they do third-party consultation, Section 26 defines a specific process for doing a consultation. And this would arise where if a record has, someone requests records, and in that record is some reference to a third party and some of their personal information, and so the question has to be asked, should we disclose that part of the record or not? And the threshold is really whether, under Section 23, the threshold is, would disclosing it cause an unreasonable invasion of personal privacy? So how do you figure that out? Well, one of the first things you might do is go ask the third person whether they have any objection to release of their documents, because ultimately it's their privacy that the section's dealing with. So that takes, there's a defined process, 30 days for the notice to that individual. That individual has to provide their response within 30 days. Then there is there's a 10-day period in which the public body has to make its decision about whether it will disclose or not, and then it has to give notice to everybody, including that third party, and then there's a 15-day appeal period before which, and that has to elapse before the document is disclosed. So that's 55 business days. So every time you find a record with personal information of a third party in it, unless there's some other reason to redact it, you will probably have to, the public body's going to have to consult, and it's going to have to come to our office to ask for the 55 days. There's really no reason I can think of that I would ever say no. It's a rubber stamp. It's a provision that requires a process. It's got a set time period, and there's really nothing gained by asking my permission. So, not exactly sure what the purpose was in setting or not sort of dealing with that as maybe an exception, but it seems to me that it would be worthy of one, because it's not. It sort of bumped up the number of files where we have these little applications to do, but it is very much a by the numbers sort of rubber stamp process. It's not an effective quality control or oversight function.
Thank you, Mr. Fox. Do I have further questions from committee? Mr. Hawkins, over to you.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I'm just thinking, although this wasn't my question area specifically, but I was just thinking on the Commissioner's response, and I was thinking perhaps it's one of these technical processes that keeps it live. In other words, people are aware of what they're doing, and it keeps a check-in thing. I mean, I don't know. I don't have enough familiarity, but he raises a clear point, which is it's a rubber stamp process, whatnot, the value of it. But anyway, it's an interesting observation, and one we will all wrestle with. Just a couple quick questions. With respect to your reporting, if I may, I do have some questions about the recommendations, but I just thought I'd start on this particular area. That's page 8 of the Commissioner's report, and I always appreciate breakdowns. I'll let them go to the page. I always appreciate stats and information on this type of thing. And perhaps it's a process and perhaps it's an interpretation in the context of terminology and way to describe these things. So one of the opening lines under overview of the numbers, and it's described as 57 files under the Act. I'm curious on to why, when you would say request the extension of time, that would be included as opening file, if that could help me. And I've seen this under, say, legalese and other processes. We are required to account for something in certain ways or say things in certain ways, and I'm curious on why they'd be defined as, like, you know, they opened a file on an extension of time. And there's 19 of them under this particular thing, and I think it's great information. That's not the issue. It's just I'm curious why it'd be consolidated in this framework. Thank you.
Mr. Fox.
Thank you for the question. I would say that the reason why it's there is, A, just for transparency and completeness. As a sort of head of business, these applications for time extensions are pursuant to the Act, formally subject to the review process set out in the Act. So it's a formal request for relief, which we have to consider. We have to give notice to the third party and to the applicant. They both have a right to provide submissions in regard to this time application. While that matter is before me, the clock on the original application is halted. So it's a real process, and it demands, it seems to me, for us to open a file. So, I mean, you know, these obviously files are open for any number of reasons, and that's, you know, that's one of the heads of business, I would say.
Thank you, Mr. Fox. Mr. Hawkins for follow-up.
Thank you. Actually, I found that answer very helpful because I didn't know the original file was paused. I think you said halted. I'm assuming you mean paused. In other words, if it has, we're saying the same thing in a sense, unless you have a reason to explain. There's a technical reason why you used halted, but the fact is I didn't realize that. So yeah, now that makes sense why another file has to be completely opened. And it's just sounds characteristically funny from my chair in the sense of, say, a citizen's perspective, which is the file has to, a new file has to be opened within the file to, you know, there's a dance there that just says it from a plain language citizen point of view of structure. But like I said, you said the word halted. That makes sense why you need an official document and process to reflect that. So that probably makes sense. You can elaborate or whatnot, that's fine. That's essentially the essence of the question. So to the to your recommendations, I just have to find my notes here. I'm just scribbling. There we go. I'm just scrolling back to mine. I'll just run through a couple. I'm not going to tie too much of committee's time up. I mean, most of them are pretty clear. I did find it interesting that faxing represents, say, 20% of the issues of breaches, and I do like your recommendation of reduce, but I don't actually like the context of reduce. I preferred your wording eliminates. We live in a time we didn't, as the old saying goes, we didn't get out of the Stone Age because of lack of stones. You know, we changed the way of doing business. And actually, I'm very clear in this small framework how as I describe this, so please don't misinterpret it. I'm really glad we had COVID because it caused us to rethink the way we do business that may have taken another generation to accept. In other words, we do video conferencing now in a way that we never would have accepted or taken years to do this. We take electronic submissions that would have taken years to get through. And as a, I don't know if you're technically practicing, but at least I'll say a current lawyer of the bar, you'll understand that, you know, the courts didn't like emails, but accept fax information, and so times change, and hence, I like, you know, sometimes it takes a big change or incident to cause people to reflect. So I would have preferred just strictly eliminate, but as opposed to reduce. I can't imagine a single government office or agency not able to scan a document that helps trace it and control it. It doesn't oversee or control errors, but it still at least has more transparency on connecting to where the problem originated from and where it started. Under number 7, the emailing one, emailing secure electronic transmissions, you know, I can't imagine I'd be the only one who's ever made this mistake by sending an email. And one of the problems with the email system that may not be fully recognized in your observation, but I think is very helpful, is the fact that when I type an email and I type in someone's name, it populates. And technology has become so easy to populate the wrong name, and with a singular glance. So, you know, that becomes therein another problem in itself, whether although we're not here to talk about text messages or autocorrect or things like that, but technology has also become a bane of our existence as well. So just as an observation, I don't have any particular issues with any of the recommendations. I've read them all. I do want to note the commissioner did spend a fair bit of time on this issue, so I just want to give it recognition or light of day in the sense of support. I can appreciate how you broke it out about the COVID agency, and you did sound like a lawyer, as in you broke down the structures as you would the argument, and I appreciate how you see the nuances of that. I would almost say that maybe in the future, one of the future considerations that you make as a recommendation, so as a suggestion, obviously not instructions to you, is that you make a formal recommendation that any emergency agency that crops up immediately falls under this unless proven otherwise. So in other words, you don't have to spell them out in the middle of an emergency saying we're now making an emergency based on these factors that we can't predict. So we have unknowns that we know about, and we have unknowns we're not prepared for. And the COVID agency would have been an unknown we never were aware of. But if we have a blanket recommendation that if an immediate agency has to come into play, the information privacy responses need to comply as appropriate. And that way it becomes a back check rather than looking at it a year later or 2 years later through investigation that, you know, the question is why they didn't, as opposed to an automatic compliance. I can't remember the phrase, but it's kind of like an automatic opt-in as opposed to as opposed to forcing them in later. So that's just my observation on the COVID. Because if we had a automatic opt-in once the agency was established, it would have had to have complied or be part of the situation that it followed your framework. So anyway, that's just an observation moving forward, but I don't have any particular issues. Your recommendations are pretty clear and thorough. Thank you.
Thank you. Do I have questions from other members for first round? Mr. Jericon, please go ahead.
Thank you, Mr. Chairman. I would like to thank Mr. Fox for doing his presentation, and I think we did this through committee in the 19th Assembly as well. I think where I sit on that side, we're doing this presentation in the evening. And but anyway, I just wanted to briefly talk about your recommendations, and but one of the things that we hear complaints about is access to information and the delays and that kind of thing. And I know the media talked about the issue of, I know Mr. O'Reilly had talked about this publicly, and trying to get information from your office. But some of the issues, the outcomes of that, from what I read, was that the delays were partly caused from staffing issues. Can you maybe talk about what we could do different to either increase your staffing issues to help address some of these issues? I understand there is a process, like you just talked about earlier, getting information, etc. But the root problem here is, what is the root problem from getting information and to getting it out the door? But going forward, though, in part of the recommendations, I don't see anything in here that talks about how we can improve getting the information out the door. So what can we do different to make it better so that we can get the information out to the public? Thank you.
Thank you. Mr. Fox.
Well, that's easy to answer. I mean, this is the fundamental project of the Access to Information Act, of how do you get government information held by a public government out to those people in the public that want to see it. And it's not easy, obviously. There are a lot of considerations. The Act is divided into two parts. Part 2 is all about protection of privacy. Part 1 is about the access to information, and it creates a general right of access, and for all, members of the public to have access to all government records, subject to a host of exceptions. And some of those exceptions can be kind of complicated to apply. Now, the regime under the Act sets up obligations for the public bodies to make responses to requests for information. So when individuals come forward saying they want to have information, then the public bodies are obliged. It's a legal obligation. It's not a policy choice. They have to provide all the records that are responsive, subject to any redactions that are justified under Division B of Part 2. So you have to have a process by which you collect, by which you sort, and then by which you disclose. And that's what the public bodies do, and in large part are assisted by the Access and Privacy Office. Now, my office, the Information Privacy Commissioner, sits entirely separate from them. When Member Hawkins asked about my use of the word halting of a file, the file that's halted is not mine. When there is an access request that's in play, if you will, when the public body is responding to it, then if an application is made to my office for an extension, the public body's time clock is halted. Mine starts, if you will. And then when a decision is made, then it's back into the public body's court. So getting responses to the public in a timely fashion, in a complete fashion, is the basic obligation that's set out in Section 7 of the Act. And there are really two ways the government can go about doing that. One is through responding in a timely way to access requests as they come. The other is a more proactive process of making information public as and when it comes into the government's possession. Now, Section 72 of the Act was amended a bit in 2021 to make it an obligation to publish the lists of the categories of information that are available without an Access to Information Act request. That used to be a discretionary choice. Now it's an obligation to publish those categories, which is not the same as a requirement to publish the actual information, but it's a step towards that. And certainly in a modern world where we all live on the internet, the idea of publishing public information on a government website does not seem that fantastical. I sent a letter out to all the public bodies last fall, asking for them to advise what, if anything, they had done in regard to the change to Section 72. And we got a couple of responses saying that they'd actually done something. We got a lot of non-responses. And then we got an interesting series of responses that were almost verbatim with each other, which was, suggested that there'd been some discussion about how to appropriately respond. Unfortunately, I wouldn't say that much has happened on public disclosure. The government has an open government policy and a directive to go along with that. And if you go on the government's website, type in open government, you'll be taken to the policy, and then there is a site where it talks about or mentions that there are open government information sources of a certain kind, and then there's another category called open data, which would be a subset of. Now, I went to the open data link yesterday, and it said what it said 6 months ago, which is that you are not authorized to access this. So it's not open yet. But to sort of address what I think your question is really getting is, what can we do? That's one thing the government really could do, is to really implement Section 72 and really put it all out there, because it is a public government. And you know, if a public body gets a report on something, you know, whatever it is, the public paid for that report. And unless it's got something that's, you know, particularly sensitive, or, you know, if it needs to be redacted in some part, why not put the rest of it up? One can be proactive in these things without having any real difficulty for the government, but it takes a bit of work. Now, on an institutional level, I think it's an open question whether it would be cheaper, whether it would be more efficient to put more information out there using that kind of mechanism, or wait for individuals to make requests. You know, if they hear about the report, whether it's tabled in the ledge or it, you know, somehow, you know, it's known to be acquired by the bureaucracy, individuals have to request it. But really, using, you know, taking that open government policy to heart, one would expect to see a lot of stuff published. So that would be my suggestion. Section 72 is a good source of jurisdiction to do that. Does that answer your question?
Thank you, Mr. Fox, and that recommendation is definitely music to my ears. Mr. Ajerikon for follow-up.
Follow-up, maybe, thank you, Mr. Fox, for your response. And yeah, I'm definitely, you know, looking at Section 72, we'll have to take a look at that and see what we could do to really help improve trying to get information out the door. But going forward, though, can you maybe just explain to me your staffing situation in your office, if in terms of trying to you know, improve the outcomes of applications coming in to get it to the people, the public itself. Because I know the media, you know, they talked about lack of staffing and training leading to privacy breaches, etc. I just want to know maybe what we could do different, or improve, how can we improve, you know, the outcomes a little bit more on this. Thank you.
Thank you, Mr. Fox, for a response.
Thank you, Mr. Chairman. I think there's, I should clarify a little bit, because I think your question suggests there's a confusion over whose office does what exactly, because my office is the Information and Privacy Commissioner office, which is the oversight body. We stand apart from the bureaucracy. So my office does not respond to access to information requests. The entity that does that now on behalf of government departments is the Access and Privacy Office. That's situated within the Department of Justice, and they operate for all the government departments. The other public bodies, independently, you know, whether it's Aurora College or an educational council, what have you, they operate independently. They still have to respond to access requests using their own resources, although I believe Access Privacy Office at least gives them some advisory help. But they're the entities that do the responding to access requests. And as I was sort of getting at earlier in regard to recommendation number 2, that office needs, you know, in my estimation, I think the office needs more resources. I know that they have been having persistent difficulties in staffing the positions that they have, you know, in terms of approved positions. I think it's an open question whether or not that's, if they were able to hit that, whether that would be enough. most of the time when I've been commissioner, they have been down. They have not been at full strength. So it's, and that at a time when their work was really on the upswing. Now, that Access Privacy Office is itself a fairly new entity. It only started acting for anyone other than the Department of Justice in, I think it was January or March of 2021. It was only a few months before the amendments to the Act came into force. So, you know, at that, before they started acting for all the public, for all the departments, they had a staff, I believe, of 4 or 5 rather. And then when they started taking on all the other departments, they had 1 more. And, you know, my sort of informal sense is that that really wasn't enough. But I have looked for a sort of disciplined analysis of what it would take to operate that office such that it could meet all its legislative timelines. And I don't know that anyone was ever able to really sit down and do that. So it seems that now, after 2.5, 3 years of experimentation, it seems that the delays in responding to access requests are sufficient. I think you can conclude that they haven't been able to hit it yet, and they need more people to do that.
Thank you, Mr. Fox. Over to Mr. Rogers for his first question.
Thank you, Mr. Chair, and my apologies to Mr. Fox as well as the chair and committee for my having to arrive halfway through the presentation, having to scoot out. My question is, when I look at on page 12 of the report, and I note that prior to 2021, the period for reviewing was 180 days reduced to 90. However, you did say in your presentation that 90 days is basically not achievable. You're a little more, here it's unlikely, but you have basically said that it's not going to happen. Now, you've also noted that there's been, since 2021, there's additional staff been working on this, but is this something that will ever be achievable? Is it, I liken it to a scofflaw. I mean, if 90 days is in there, but 90 days is not even something that's in the realm, and everyone is going to have to ask for an extension, is there something that, I don't know if it's a question for ourselves or it's a question for you, that we can do to ensure that we can at least reach what we have in the Act rather than just having it in there as a number? Thank you, Mr. Chair.
Thank you, Mr. Fox.
Well, the timelines in the Act, there are a number of different timelines, and they are mostly couched as mandatory. Now, the timelines that face the public bodies in terms of responding to access to information requests, those changed a little bit in 2021. They went from 30 calendar days, you know, the first period, 30 calendar days, that was changed to 20 business days. Not really that much different to an applicant, although when things like Christmas holidays roll around, it can have a significant impact on when you can expect it with the way the calendar works. So business days was an important change. Did the bureaucracy assess the situation and decide, yes, we can do that, you know, in whatever percentage might be reasonable? In half the cases, 75% of the cases, can the public body provide the response within that first 20 calendar days or 20 business days? I don't know how often that happens. The Administration of Justice report on the Access to Information Act suggests that they're still struggling to meet the timelines in at least 30% of the cases, I think. And you know, let me put it this way: a lot of requests can be quite onerous to respond to. I know that there were a couple that from last year where they were grappling with collections of documents in excess of 10,000 records. So that's a lot of work. And in a small office, that can land like a bomb. So the timelines that office faces are difficult, but that is why there is the extension provision. So they can grant themselves one extension for 20 business days, and then after that, if they still need more time, and that can basically be because if the volume of records is such that responding is going to unreasonably interfere with the operations of the public body, they can come and ask for an extension. If they have to do consultation with a third party, or perhaps another public body, that's another one. There are a couple other typical reasons that the Act contemplates in Section 11. But if they need more time after that first extension of 20 days, they have to come to my office to ask for it. And then, we deal with that. And we try to get those out the door fairly quickly because, generally they're fairly straightforward. And as I say, when we are contemplating that request, the clock stops. And as I understand it, often that is treated as a relief, and the people working on that file will stop working on the file and go work on another one. So we don't want to be the bottleneck. We try and get that out. And those we can turn around fairly quickly because generally the issues are pretty straightforward and pretty easy to handle. But if someone gets a 5,000 page disclosure and then objects to the number of redactions that are in it, they come to our door and say, well, we want you to review what the public body has done. And that can be quite a lot of work. We basically have to redo or review everything that was done. We have to ask for submissions from both sides. At times there's disagreement about how various sections allowing redaction are to be applied. Sometimes there's more discussion required. And a decision has to be issued. And because one of the other changes was that my office now issues orders in the context of access to information reviews, it's really important to get it right because the government's bound by the order, and you can't make an imprecise order. And you can't leave it to, I think, be quite irresponsible to sort of leave it to the public body to decide whether it was, quote, worth it to appeal it to a court. So my view is we have to be very careful and make sure that we're right before we issue an order, and that's a time-consuming process. And I spoke about how you asked about how the 180 days changed into 90 business days, and is that enough? Well, when it was 180 calendar days, about 6 months, the average turnaround time for an access request file was about a year. So in the face of that, the decision was made to reduce the time to about 4.5 months, or 90 business days. I don't know why. I don't know why there would be any expectation that simply changing the rule would change the amount of resources available to discharge that. It is if I can be candid, a not unheard of government response to a problem to say, well, let's change the rules. But the rules were not the reason it was taking a year to get a file out of our office. The rules were not the reason it was taking a year or more to respond to an access request. The reason that was happening was because, and it continues to happen, is because the resources aren't there to do that amount of work. So our office increased its staff by 1 in 2022. We got an investigator position, and I have high hopes that perhaps by the end of this year, we're going to be, if not caught up, a lot closer. But you never know what the future holds. So I'm just not sure that I've got anything else to respond to you on those questions, if that helps.
Thank you, Mr. Fox. Mr. Rogers for follow-up.
Thank you, Mr. Chair. And yes, thank you for the answer. It does help. And again, I guess that's information I'll have to gather as to why the recommendation was made to reduce it from 180 to 90 business days, when it's clear to me from what you were telling me that that was never going to be achievable. I do note in there that it has, you had said you've had a double the amount of files coming since you've hired your new employee or investigator as well. Nothing else, Mr. Chair. I read the report. I think the recommendations are reasonable, particularly number 3, obviously, based on the question that I had just asked, that those extensions be granted. And other than that, just to thank Mr. Fox for his presentation. Thank you.
Thank you. I have Ms. Whalen Armstrong next for round 1 questions.
Okay, thank you. Thank you for the presentation. Yes, this is further to what my colleague said regarding fax. I know faxing patient information is a great concern for many still. I just wanted to ask, and I know here one of the recommendations is that for health info custodian continue to reduce or eliminate the use of fax machine. Will this apply to the prescription? I know many of the health center or the hospital, they fax prescriptions to the drugstores, and those have patient information still. Will this apply to that as well?
Thank you, Ms. Whalen Armstrong. To Mr. Fox.
Thank you for the question. So a couple dimensions to that. Faxing has historically been a real source of privacy breaches for health information custodians, and although there have been recommendations made in a number of years to reduce or eliminate faxing, and I've made that recommendation in a number of review reports of privacy breaches involving faxes, faxing continues to be a fact of business in health information custodians, particularly the health and social services authorities. Although I will say that from what I'm told and from what I've seen, it seems to be reducing. There are other methods to use to exchange information, and apart from using the electronic medical record system, there are secure file transfer methods, there are passworded documents and email. There are strategies that you can employ that can mean you can avoid using faxes. However, fax machines by themselves are not the enemy, if you will, and sometimes they're necessary. If a pharmacy in your community doesn't have the right kind of email software, perhaps that's the only way you're going to get the prescription to get to that pharmacy in time. And I'll say this, I mean, we're seeing a bit of a decrease in faxing errors. We're seeing an increase in things like scanning and linking errors, where documents are scanned and then linked to the wrong person's electronic medical record. None of these systems are, I'd say, foolproof. They're not without error, particularly if people are rushing or for whatever reason just not catching it. As Mr. Hawkins pointed out, email systems often auto-populate address lines when you're sending emails, and if this happens not infrequently, that the wrong person, you start typing Andrew and then it's not Andrew Fox that pops up, it's Andrew somebody else, and you don't spot it, and suddenly you've sent an email to the wrong person and you've got a privacy breach. So, I mean, no particular technology is the panacea. Faxing has some problems with it, because once you've sent, you can't really pull it back. With email, you can pull it back. With email, you can put passwords on the attachments, and with secure file transfer, you can have other controls to make sure that only the person who's supposed to get it gets it. With the specific example of sending a fax by mistake to the wrong pharmacy. Pharmacies are health information custodians, just as hospitals and health centers and doctors are. as health and social services authorities are, and doctors, pharmacists are, and they're therefore controlled by the Act, and if they receive the wrong facts, they've got an obligation to report that. And you know, we see any number of variations of the wrong documents being sent to a pharmacy. And in general, I will say that, you know, pharmacies are pretty responsible about, you know, when it's reasonable that they can spot that there's an error, that they take appropriate steps to deal with it. Thank you, Mr. Chair.
Thank you, Mr. Fox. Ms. Whalen Armstrong, do you have a follow-up question?
Yes. Yes, you said that, you know, okay, vaccine info, you know, they're reducing, you know, vaccine patient information. So which is good, you know. I mean, that's good. That's a good sign. But for patient information and for prescriptions and all that, is there timelines of when do you think we will see some elimination of vaccine, those informations?
Thank you. To Mr. Fox.
Well, I think that question would be best answered by you know, a CEO from one of the health authorities. I know I've had meetings with the CEO with NTHSA, and I know that one of the considerations, obviously, is that, you know, there's no bottomless pit of money to simply replace old technology with new. And this is an issue with printers and fax machines and scanners and all this sort. So, as I understand it, you know, as the technology improves and as money is available to purchase that new technology, they're not resistant to change. But by the same token, there often is resistance to change when you come to individuals doing jobs that they've been doing for a while and are comfortable that if they do it this way, the information will get to where it's supposed to go, and there can be a distrust of a new way. It takes a real top-down, motivated management sort of decision to change practices, like how do we send information to the people that need to get it, whether that's a locum doctor who was up in Hay River and is now in BC somewhere but needs to know about a patient, or whether that's about an x-ray that has to be sent to Calgary to get read and then sent the results sent up here. How does that happen? Does that happen electronically, or does it get sent by mail? Does it get sent by email? Does it get sent in a specific kind of a electronic format? Sometimes we still see information being put in an envelope and walked across town. Sometimes those envelopes fall in the parking lot. But getting the information to the people that need it is probably going to continue to change the form in which that happens. But it's really attending to detail and the security that is most important. I mean, frankly, if you take a piece of paper and you put it in an envelope, and then you double stuff that envelope with a return to sender address, and you give that to someone to go deliver, that's probably pretty secure. Things can go wrong, but that's pretty secure. You press an email and you don't pay attention to where you send it, that could potentially be a much more significant privacy breach. So technology isn't always the answer, but it does have, if used properly, it does have some really good features to it that could be the answer.
Thank you, Mr. Fox. Mr. Fox, I'm just wondering, do you have a time that you need to be gone by?
I'm here.
This answer.
Okay, thank you. I appreciate hearing that. I just note that that we've got audio staff in the booth there who probably desperately could use a break. So why don't we take a 10-minute break? We'll come back at 3:25. 10-minute break, 3:25. I think we do have some more questions, so we'll come back at 3:25 with some further questions for the Privacy Commissioner, and we'll reconvene at that time. Thank you. Okay, thank you. I'm going to call the public meeting back to order. Thank you very much, everyone. And I'm going to turn it over to Ms. Reid for a second round of questions, and just noting that we all want to be respectful of each other's times. If we could keep both questions and answers as quick as we possibly can. Thank you.
Thank you, Mr. Chair. And thank you again to Mr. Fox for all of your very thorough answers. You've raised concerns about the privacy impact assessments in the health sphere being submitted without a reasonable amount of time in your introductory comments and in your report. Specifically with the ability to review and implement new information systems or communications technologies. And you recommend that under recommendation 10, I believe, to change the Health Information Act to add provisions that align with the ATIP Act and address some of these concerns, hopefully. So my question is, though, do the allowances under the ATIP Act, those provisions, does that mean that your office's review of non-health related privacy impact assessments have a reasonable amount of time for review? Is there an understanding it's not a tick box exercise, to use your words? Is everything tickety-boo, I guess is my question. Thank you.
Thank you. Over to Mr. Fox.
Well, tickety-boo isn't a term of art I really couldn't get. But let me address that. We have not received a lot under ATIP. Under ATIP, there's a sort of two-tier level whenever the public body is going to engage in some new information system or record management system, etc. They do their PIAs, but it's only when it's and they have to provide those PIAs to their head. It is only where it is a common or integrated program or service that they have to submit the PIA to my office. So if it's a project that's going to involve more than one department, think of it that way, then a PIA needs to come to my office. We've only had a couple of those, and I'll say encouragingly, we got one last year that was for a pretty big project, and we got it as sort of an initial draft, if you will, and there were some there were some big pieces that hadn't been filled in yet, and I was quite appreciative of it, because the PIA is a planning tool, and it's really in its most sort of idealized form. It's an iterative process. You take a look, the project proponent will take a look at what the privacy or potential privacy implications of the project are going to be, analyze them, figure out what mitigative measures they can put in place to protect privacy. Then they turn it over to our office to have a look and make any comments. And then if we find something that is particularly significant and or ameliorative, then we will make those recommendations, and then again in the planning phase there's an opportunity to work those into the project before you built it. And on this one that I'm mentioning, we got version 2 just a couple of weeks ago, and somewhat concerned to hear that they were hoping maybe to go live with this project in May or June, but we're gonna get through it. But we've already seen it once, and I'll be looking to see what additions have come, because I know that the project has expanded a bit. But I would say that the experience, at least with this one project, has been that departments are really paying attention to it.
Thank you, Mr. Fox. Ms. Reid for follow-up.
Thank you. And this might be a bit of a stretch on a follow-up, but I think it does tie together insofar as in your annual report on page 8, I understand the reasons why I think you've selected the pieces that you have selected in terms of like how you're opening files, how you're responding to certain sections under the Act, or acts, I should say, both acts. Is there a possibility of providing future annual reports that represent key indicators such as PIAs over time? So things that you're receiving in your office and reviewing and demonstrating that in your annual reporting, so that it would allow someone who's reading your annual report to see trends easily identified year over year. I think that would be helpful for us as members and possibly the public at large. Thank you.
Thank you, Mr. Fox.
Thank you, Mr. Chair. Just to clarify, if I'm understanding you correctly, you're thinking it would be helpful for future reports to have not just the current year's numbers, but perhaps the previous 1 or 2 or 5 years. I mean, in theory, the data is already there. It's pretty easy to reset. Wouldn't necessarily even add that much length to it. We can certainly take that into consideration. Certainly when I came here today, I was looking back into a couple of years past reports to see, like, well, where are we in terms of numbers? And sort of, you note that, well, we're up or we're down and how much. So point taken. Yes, we'll look at that.
Thank you, Mr. Fox. I had Mr. Jericon next, but he's not here. Mr. Hawkins.
Thank you, Mr. Chairman. Mr. Chairman, if Mr. Jerrican's not back, I'll certainly take his question for him, and happy, because I know the general sense of where he wants to ask. But for starters, I'll focus in on my particular question. The Privacy Commissioner sort of deals with what we'd like to think is, or maybe we only know is known complaints or known issues and known inquiries. In other words, someone has to launch an inquiry or of some sort. They have to table some type of question for them to either manage or even to account for, which is a difficult thing to imagine if you don't do it that way. So how would he qualify or understand the expression of how deep the concerns really go? And I'm curious as it's an easy question in the sense of I'm giving him a lot of wide berth on the response of this question, which is, has he put a mind to the question of, like, how difficult is it to assess the non-filed complaints? And I want to give him a simple, clear example of that. So a couple months ago, I had inquired with the Department of Health to send me a form. They had sent me a pre-filled out form that was already filled out with personal details of a constituent and an MLA, etc. I deleted it. I mean, to the best of my knowledge, I'm pretty sure, 99% sure I deleted it, but I also let them know at the same token. So when I qualify it this way is, there's probably a lot of informal privacy issues that are happening that are unreported. And I just wonder, has he put a mind to this particular challenge? And, is there a way for him to take a stab at how we address this? Because, I don't know if I'd done the wrong thing. I just reported to the department, you sent the wrong thing, and hence I deleted it. I mean, to me, that was the right thing to do. But that said, maybe the right thing to do would file a complaint or an observation in the Information and Privacy Office as to the analysis of what there. And so back to the point is that, does he have any thoughts, maybe not stats clearly, but does he have any thoughts to how many of these are being dealt with informally without being reported? And start with that. Thank you.
Thank you. Over to Mr. Fox.
Thank you for the question, Mr. Hawkins. Mr. Chair, I think the way to respond to that question is to look at the way the two different acts operate. So under the Health Information Act, if a privacy breach happens, no matter what kind of breach, if a health information custodian is aware of it, they have an obligation to report it to my office. So that's the mechanism that Privacy Act, or that Health Information Act breaches arrive in my office. Now, that relies obviously on the health information custodian doing its job under the statute. Do all information custodians acquit that obligation thoroughly at all times? I don't know, but I observe that it is the law, and I think that most of them are attempting to obey the law, and certainly we have a lot of reporting that comes in from certainly the Health and Social Services authorities about breaches that, you know, one might look at and say, well, that's not a terribly egregious breach. You know, if someone, for instance, if someone's health information recorded on an x-ray form is mistakenly sent not to the ward the patient's on, but sent to the emergency department, that's technically a breach of privacy because it's being sent to someone who doesn't have any need to see it. But it's not, and we are to be notified of it, and we are. So that's the way that happens. So is there a, if your question is, well, how big is the pile of unknowns? Under the Health Information Act, there's no threshold. So if it's working properly, we should know all of them. Under the Access to Information Act, the regime's a bit different. Up until 2021, there was not actually a positive obligation on a public body to report a privacy breach. Subsequent to the amendments coming into force, there is a limited one. If there is a privacy breach which reaches the level of what the Act calls a material risk, then the public body has to notify my office. And there's some statutory conditions to help you figure out whether you've hit material risk. And if in either my assessment or the public body's assessment, that risk goes even higher to reach the threshold of reasonable risk of significant harm, then the individual has to be notified. And there's also potential for a process for review by my office. And that can be informal or formal. It could be, you know, it'll be adapted to whatever the circumstances are. But it certainly could go to a formal review report and formal recommendations. But the public body only has to report privacy breaches that hit material risk. So for events that don't meet that threshold, I would never know about it.
Thank you, Mr. Fox. Follow up to Mr. Hawkins.
Thank you, Mr. Chairman. I mean, ultimately, the from what I think I heard, maybe perhaps I understood, was the obligation actually would have been the department to point it out as opposed to me, or certainly that would have been their key partner in the responsibility of taking it serious. And I mean, when I say the next phrase about, you know, what's the hammer, it's not about making someone pay, but what happens when you do these types of things, both material or immaterial? Like, I mean, you know, I often think about these no-fault processes, and I think they're very helpful because you want people to say, hey, look, other than a shame on you, do better. You know, you're not carrying this weight of guilt or financial penalization or fear of being reprised against a firing. I'm just curious on what happens next in these particular cases, because if there's a fear of some type of heavy hammer coming, these I'll characterize it as minor, but I mean that may not be the appropriate phrase. But for discussion purposes, is these minor faults may go overlooked and not reported because of concerns of feeling like the standard response people are concerned. So I'm curious on what happens next on those particular initiatives. So, like, what happens to these folks when they've been identified as this error has been made? I don't know.
Thank you. Mr. Fox.
Thank you, Mr. Chair. In the instance where a complaint comes, if a report of a privacy breach comes to my office, be it minor or significant, we will first be given a breach notice, which will give very bare bones facts of what might have happened, and then there will be a final breach report. that will outline the circumstances in detail. It'll describe, what, if anything, has been done to mitigate the specific impacts of that breach, and there will also be, or maybe, other measures that have been taken to try and prevent similar things from happening in the future. And ultimately, that's the project when you're dealing with privacy breaches. There's no fixing a privacy breach because it's happened. You can really only effectively look at what's going to happen in the future and try and prevent the same thing from happening again. And that's, the way the Act is set up, as I say, it's no fault. I mean, there are a few provisions for penalties for willful behavior, but generally that is not what's going on in the context of this sort of stuff. It's all about inadvertence, lack of attention, and the project is one that is what I would call a cooperative in nature. The process involves reporting out to the Privacy Commissioner's office for an independent oversight view, and then we will discuss with what happened with the health information custodian, for instance, or with the public body, and more often than not, the individual is not part of that discussion because the individual has decided not to participate. But that's fine, because I think it's fair for the individual to assume that government is attending to things the way they're supposed to. So the public body or the health information custodian and I will have a discussion in the context of, generally written conversations where questions are posed from my office and answers are received. That can be an iterative process, and then we will, if we're going to do a formal report, then we will write one, and it'll summarize the facts, and it'll sort of set the issues to be considered, and hopefully arrive at some recommendations with a view to preventing similar events from happening in the future. Now, not every privacy breach is unique and unprecedented, so often, particularly with the more, when I use your words, minor breaches, we will take a look at it and we'll have that conversation, and then we won't do a review report. We will do a letter to the entity and say, well, you've done this and you've done that. Well done. You might consider doing this or that, and that'll be the end of it. So that's what the process looks like. And individuals who are actually affected under the Health Information Act, they always get notice of the privacy breach. And as I said, under the ATIP, that's not necessarily the case. They'll only get notice if it hits that threshold of reasonable risk of significant harm. But nevertheless, there is a notice provision. Most individuals choose not to participate, but they could. And, ultimately, my office relies on the assumption that the public bodies are listening, that the information custodians are listening, and that they are attending to, their legal obligations, which is to ensure that reasonable security measures are in place to protect the personal information, to protect the records that that information is held in.
Thank you. I have Mr. Ajerikon next for follow-up. Do you still have a question, Mr. Ajerikon?
Thank you, Mr. Chairman. No, I just want to come back to one of the questions I asked earlier where you talked about staffing in the Department of Justice. My issue and concern is that when we take a look at the breaches are stemming from the lack of staff that we have, and you mentioned that there's 5 staff that at the Department of Justice, but overall, some of the complaints that I've been hearing from as a MLA, in the 12 months, sometimes we what I hear is that to complete a review from your office takes 12 months versus the statutory 90 days. I guess to do better in these areas, I mean, we could look at your recommendations and going forward and try to help improve their situation. But overall, you know, what is the real root issue here? Is it the lack of staff in your office or in the department staff in the justice area? But to do a review from your office and taking 12 months versus when it should take 90 days, what can we do different here? And maybe you could explain why is it happening, and what can we do so that we can improve the outcomes so that the public is aware my application went in, I should have an answer in 90 days, not 12 months. We've got to give assurances of comfort to the public that, you know, I'm trying to nail down exactly what the issue is. Is it staffing issue or is it money issue? Because like I said, you got your 10 recommendations here, but I don't see those recommendations addressing this issue here that's confronting us. And at the end of the day, you know, we have an act, you know, we want to make sure that the public is getting the information they need. And what are the barriers? So what can we do to fix these problems? Thank you.
Thank you. Thank you, Mr. Jericon. Over to Mr. Fox.
Well, the challenge to doing work is typically you need the power to do it. You need the resources to do it. And I think it's fair to say that you know, the Access Privacy Office has been challenged in terms of having enough staff to respond in a timely way to all of the access to information requests that they have received. That's why there are you know, 30, 40, a couple of years ago, I think we were hitting 50% late. 50% of the files, they were getting the responses late. And I think they're making improvements on that, but the last figure I saw was something in the range of 30%, which is still pretty high. There's really no getting around it. If you if you have more work to do than you have people to do it, you're going to fall behind. And one of the legitimate problems that office will have is that this stuff comes in ebb and flow. It is a process that is driven by public demand, and that can change. I know I was looking at the last couple of reports from the Administration of Justice on the ATIP Act, and their numbers went up from, I think they went up from the previous year. Curiously, ours had gone down. It really depends on, you know, how many files or how many requests for information you get in, and it also depends on how big those asks are. I know last year that office was struggling to meet a number of applications, and then they got one in for 15,000 pages. Well, the request they got in generated that much. Well, how does a person sit down and read through 15,000 pages, many of which will be umpteen duplicates or somewhat duplication of the same email strings? That's hard work. It takes a lot of time because you have to maintain focus, and you have to know what you're looking at and know what all the exceptions are under the Act, etc. So it's not easy. You get a couple of big files in your office and you've got a staff of 4 or 5, you don't have surge capacity. You just don't have it. So that's going to have ripple effects on all the other work you're doing. And that's just the nature of running a small operation. Now, let us not think that the GNWT is somehow unique that way. Somewhat notoriously, a couple of years ago, there was a person who had applied for an access to information to some RCMP documents, and there were approximately 750,000 different records available. And Library of Archives Canada estimated at first instance that it would be approximately 80 years before they could provide the response to the access request. And then the Federal Access Commissioner said, why don't you go back and think about that again? And they came back with something, I think it was on the range of 50 years or something. And, you know, the applicant was not a young or well man, and unfortunately, by the time that got to the Supreme Court of Canada, he had passed on. And I'm not sure that they ever weighed in exactly on what reasonable is. But there is no limit on what an individual can ask for, but there are definitely limits, physical limits, on what individuals can do. So, and there are real limits on the kind of resources that any government is going to place on this activity at any given time. There are lots of competition. There is lots of competition for government resources. Now, I've said it before, I'll say it again. These are legal obligations. They're not policy choices. So when weighing out where money should go, it would seem to me that the legal obligations should have a pretty strong purchase on the budgeting decisions. Those budgeting decisions, of course, respond not just to what resources are available, but what is the work to be done. And you know, I can't say that I can speak authoritatively about how many staff the Access Privacy Office would need to hit, you know, a good average of being able to respond in their 20 business days for your average access request. I would hazard the guess that they would need more than they have now.
Thank you, Mr. Fox. Mr. Jerkon, do you have a follow-up to that question?
Well, maybe I'll make a real quick one, just a quick observation again. You know, I'm just thinking about this whole thing here. The recommendations that were put forward, and if this issue in terms of staffing is not addressed, it doesn't matter what we put forward for recommendation. It's not going to work if we don't deal with the issue itself, which in this case would be staffing, because it's going to take us another 12 months to put an application forward, only to be heard statutory in 90 days. But then if that problem is going to be there, then this problem is not going to go away. It don't matter how many recommendations we put forward. So overall, again, I'm saying is that as a government, we need to do better. We create these acts, and you know, the way I look at it is that if the public and the community for resolution need information, and I don't think they'd be really upset if they got to wait 12 months to get a reply or a response back to them, and it's just not good enough. So I like what you're saying. You know, yes, I read the report, I went through the recommendations and all, but we got to do better. Thank you, Mr. Chairman.
Thank you, Mr. Jerkon. Anyone else for round 3 questions? Maybe we're on round 4. Seeing none, I'm going to go back to Ms. Reid for round 5.
Thank you, Mr. Chair, but in the interest of everyone's time, I've actually forwarded some questions to the Commissioner by email. Thank you.
Mr. Hawkins, I have you last.
Thank you, Mr. Chairman. Maybe what I can do is turn it into a request of information for follow-up for the committee at large. And I'd like to ask the Commissioner if he would provide the committee a flow chart for a fresh, I always hate to use the word complaint, but anyway, inquiry or whatnot, application for consideration. And if he could provide the flow chart showing where the system in days and process-wise can change. So in other words, it comes in, it has a 30-day window to deal with. Within that window, it goes to the first stage of response. You know, that's a 30-day, not 31, as in that one's 30 days, etc. So we could see. And I think that this would be extreme, etc., etc. I think if he could nod his head if he knows what I mean or he wants me to elaborate more examples. But what I think would be helpful for us is committee members is often we hear the system breaks down or is a problem no different than my good colleague here, Mr. Jerkon, had pointed out, you know, expectations. And without intending to offend, is the problem your office? Yes or no? Is the problem the department ignoring a response? Yes or no? Like it helps us understand where the breakdown starts and then it creates the ripple effect. And then we can ask the other question is if it's been delayed, and again, not picking on the Commissioner, but if it's delayed at your office, then we can ask the question, explain to us, oh, it's a complicated file, 100,000 pages. Obviously, that's a very difficult problem to manage, that seems to be self-explanatory. But if staffing is an issue, that's a reasonable response, and hence it allows us to sort of tease out some of the issues and the anomalies. Because I do hear as well from, you know, no different than my good colleague here, Mr. Jarkon, is that sometimes it's slow. But slow is very subjective, and slow doesn't really help resolve what the issue is. It's just we hear it's slow, and that doesn't mean a lot, generally speaking, without understanding the fuller context. But if we had a sense of understanding the process, better timelines and off-ramps and delays and mechanisms, then we can maybe lean on the department and say things like, okay, well, you know, you're given a 30-day or 90-day window to respond. I think it's 90 days. But that said, you need to be responding. What's the problem? You're slowing the process down. Hence, we're denying natural justice to your office, and furthermore, we're denying natural justice to the original complainant. And if that's really what I'm hoping he could come up with, some type of flowchart process and a little bit of a narrative that explains the natural intent of a file. Thank you.
Thank you, Mr. Hawkins. Mr. Fox, it looked like you had a question of clarification, but is that as clear as mud for you, the request?
No, I think that's a good idea. I'd just like to clarify whether we're talking about a flow chart for how is a fresh complaint. I mean, we call them applicants, but if you're talking about someone who's got an issue with the response that they got to an access to information request, or is the issue you want a flow chart about how our office deals with notices of privacy breaches, or perhaps you want both?
Thank you, Mr. Fox. Have you seen Schoolhouse Rock? It's just a joke. Mr. Hawkins.
I haven't. Now I'm really curious. It's usually me asking those questions. Okay, so I would like both because, again, to get us a context of how these challenges are. I mean, this seat, and I don't want to go in too long, this seat, it's easy to, as my good colleague Mr. Miltenberger used to say, it's easy to throw spears and it's a lot harder catching them. So in other words, it's easier to complain about the process without understanding some of the complicated factors behind the scenes, which sometimes explain everything. But without knowing that, and hence the multiple, I'll leave it in your good hands to decide what would be most useful for committee, and we can proceed from there. But I think a couple variations make the best sense, and through that, maybe the chair may eventually share with all members, so we have a better sense of understanding that essence, and we can also be part of the problem or part of the solution, and I'm hopeful that that will add to the solution. Thank you.
Thank you, Mr. Hawkins. And if I may, I mean, I think what members are trying to get at, Mr. Jericho and Mr. Hawkins, is just we're trying to get at what is the key problem here, and is there something that we can do to intervene in the system to help speed up these requests? So if you want to take that back and think about it, the committee would be interested in hearing from you, whether it's in the form of an informational video, an infographic, whatever you see fit. But is that pretty clear?
Yes. Much clearer than the question about Schoolhouse Rock, but
excuse me, Mr. Fox, just a joke. Well, if you've seen Schoolhouse Rock, it's an animation where they show kids how things work. The one that I remember from my childhood was they walk a bill through Congress. It's you know, it's an animated show that teaches people about how things work. So I thought a Schoolhouse Rock about the Privacy Commission could be a great idea.
I was thinking of the School of Rock. Completely.
Okay. I think I'm going to digress. We are in a public meeting here, and so I want to thank you, Mr. Fox. I think 4 o'clock is a good time to wrap this up. I would like to thank you and our other statutory officer for appearing before us today, and thank anyone who tuned in to the meeting on our live stream. This now concludes the public portion of our meeting. Committee will take a very quick break as Mr. Fox packs up, and we close the public portion of the meeting, and then we'll get back to it. Thank you.